keeping our eye on some of these Private Attorney Generals Act cases, the PAGA cases, and Ann's going to discuss the Estrada case.
Yep, I think that's an extremely important case, and it's set for oral argument November 8th this year, so we can expect a decision really, really soon. The case is Estrada versus Royalty Carpet Mills. It's being reviewed presently by the California Supreme Court. The issue before the court is, do trial courts have inherent authority to ensure that PAGA claims will be manageable at trial? And if so, can they strike or narrow or dismiss these claims if they cannot be managed in a reasonable manner? So what's going on right now is the Supreme Court in this case is going to be resolving a split of authority between two appellate courts regarding whether trial courts can strike or limit or dismiss PAGA claims. Contrary to Estrada, the appeal court and the trial judge, the court in Wesson versus Staples held that courts have inherent authority to ensure that PAGA claims can be fairly and efficiently tried, and if necessary, they can strike the claims that cannot be manageable. So this is a real important case to keep your eyes out on it, especially if you're involved in pending PAGA litigation right now. And we certainly have lots of those to keep an eye out for.
Yeah, and the second PAGA case we want to discuss is the Lyft case. You know, with the class action waivers that can be implemented in arbitration agreements, we've seen a huge increase in the PAGA cases, PAGA-only cases. And what's happening in a number of circumstances, and I believe in this Lyft case, there was 3 pending PAGA cases against Lyft at the same time. Lyft went and settled one of the PAGA cases and wiped out, argued that because the settlement in one case wiped out the other 2 cases. A plaintiff in one of the other 2 cases showed up at the settlement hearing for the settlement that Lyft had reached and started to object to it, saying it wasn't fair. And Lyft was arguing, well, you don't have standing to show up in this other case that I've settled and object to the settlement that I reached with this other PAGA plaintiff. So it's a critical issue that we can see. We're seeing this issue come up quite a bit in PAGA, where a larger employer has multiple PAGA cases or potential PAGA cases. When there's one case that's settled, what impact does it have on other cases? And what rights do the plaintiff in the other cases have to come in and object to your settlement that you reached in one case? So it's fully briefed. We don't know when we'll have a decision on that, but it's something we're all keeping our eye on here on the PAGA front. And also in regards to arbitration, this California Commerce Club case is deciding an issue as if the defendant has waived its right to bring a motion to compel arbitration when it waited 13 months after the lawsuit was filed and engaged in discovery, and then tried to compel arbitration. The plaintiff argued by waiting so long, they waived the right to bring a motion to compel arbitration. So we'll see what that issue, how that is decided here by the California Supreme Court. But just a reminder for employers, you know, when you have an arbitration agreement and they're implemented, have a good file system or electronic file system to make sure that those are documented and stored so that you can easily get those. And it's not going to take a long time to discover those. Or if you lose them, it's hard to, you know, obviously to enforce them when you can't find the agreements. So how you maintain those and how quickly you can find those is key in this issue to avoid any kind of waiver arguments that are coming up in that case. Now, also, time rounding is an issue coming up in Camp v. Home Depot. I usually don't take a whole lot of predictions on how the California Supreme Court is going to decide these issues, but I'm going to go out and make a prediction on this one that I'm going to predict that the California Supreme Court is going to hold that time rounding is not permissible under California law. It has already been eroding away this concept of time rounding that's been permissible under this old See's Candy law. But we had a decision a couple of years ago in the Donahue decision that said time rounding is not permitted when it comes to recording meal breaks. And I have a pretty good feeling here that the California Supreme Court is going to say, look, time rounding is just not permitted under California law. So if you are rounding time, it's been our advice for a long time to keep an eye out. And, this doctrine is probably on its last legs here. And if you are rounding time at all, you need to be careful. And obviously can't do it for meal breaks currently under California law, and probably not at all here after this decision comes out from the Supreme Court. And then I wanted to mention this case about harassment, discrimination, and retaliation, Bailey versus San Francisco District Attorney's Office. This case is looking at the standard on what it takes to create a severe or pervasive environment to alter the conditions of employment to bring a harassment, discrimination, or retaliation claim under California law. And the issue here was there was one racially motivated statement made by a coworker, and was that one statement enough to create a claim under California law? And also the other issue here that's going to be reviewed is if the plaintiff can't establish a claim for discrimination, harassment, can they continue on a retaliation claim if they can't establish the underlying discrimination or harassment claim? So that's this Carter rule. I have the case set out there, is being reviewed by the California Supreme Court as well. So important to pay attention as well going forward. And then finally, this last case that I mentioned is the Iloff case. We're getting into the weeds a bit, but it's some important decisions will be coming out in this case about whether employers have this good faith defense, or what the standard is for a good faith defense to avoid liquidated damages in a wage claim. Employers have this defense available to them, but it's going to clarify that standard. And also, it's going to address the issue of whether a plaintiff can sue for failure to provide paid sick leave under the Healthy Workplaces, Healthy Families Act, and whether there's a private right of action under that law. So stay tuned on that. It's a good decision to review if you're a wage and hour practitioner. It deals with a lot of issues about personal liability as well. Quite a few issues determined at the lower court on this case too, but we're all keeping our eye on that.